So I think a real show begins now. Of course, this was all overview. You got some feel of what's happening around in India. And if I may now invite our panelists for the first session, Mr. Daniel, all of you, I think, know, that Mr. Daniel has been the General Counsel, President and General Manager, Emerging Pharmaceutical, and has significant deal-making experience in India and globally. So Daniel, can I request you here? Thank you. Vaibhav Parekh, our partner, in charge of M&A and private equity, and same Nishal Joshipura, very quickly. Simone Rice, she is the head of M&A and also competition law, antitrust practice group, and Mansi again, head of US operations. I was just giving a little warning that we'll extend our session a little bit because Mr. Mule was very interesting to listen to and to give overview. So we'll extend it by half an hour. It will eat into or drink into your cocktails a little bit. And I'm sure everybody is more thirsty for knowledge than alcohol. So anyway, so let me start with Vaibhav, what are the areas where you foresee potential M&As, activity happening, and what are the drivers for this M&A activity?
Yeah, thank you, Nishith Bhai. I think Mr. Mule already told very macro drivers, which is making India very interesting. 2 points he mentioned. One, the growth rate is excellent. Second, the government is actually focusing on ease of doing business. Government is actually looking at taking this as a two-pronged approach. First, they are trying to reduce reduce obstacles. Basically, the theme is to be an obstacle or be ungoverned. They are looking to remove 1,100 laws which have become redundant in a very short time frame. So those kind of initiatives they are doing. Similarly, if you look at what Avi mentioned on startup, I was there in the startup event as a special guest for Prime Minister and also had a one-on-one meeting with a group of Thai with the Prime Minister. And during discussion, all what it came out is that government is looking and seeing how they can unobstacle, how they can ungovern by reducing the legal and compliance which current regulations pushes on them. To answer your question, and I'll be brief, we have actually done a hotline, which I will send it to you maybe today after the event, where we have analyzed the startup action plan, which Mr. Modi, Prime Minister Modi released on that day. But in essence, what they have done is they have focused for startups on ease of incorporation. They are saying that instead of 20, 21, 30 days which it takes today, company can be incorporated in a single day using mobile app. So you really don't need to go to any offices for incorporation. On your mobile app, you can incorporate a company. Similarly, closing down the company also can be fast. Currently, it takes 2 years to 3 years to close the company down, which may be reduced to 30, 90 days for most cases. And there are a lot of drive towards self-certification. So instead of going and complying, all you need to do is self-certify. So that's the focus they have. Then there are certain tax initiatives which has been given to startups on capital gains tax, on income tax, etc. And then there are certain initiatives they have announced which will permit, for example, if they want to file patent, then they can take benefit of free advisory which government is going to provide. They have subsidized cost for filing patents, and so on and so forth. These are the initiatives to kind of create or help startups to meet their potential. So that's a step they have done. We have an in-depth analysis. Anyone is interested, please tell us. I will email it to them. It should be there on our website also. But after small discussion startup, if I come back to the macroeconomic drivers, which government is doing, and the reason why we believe M&A will become a very, very strong growth in India, I think we're looking fundamentally as there are 2 or 3 major factors. One is that there will be a lot of consolidation in a lot of areas where we feel that because of there has been a little bit squeeze in the market in terms of funding, which we are seeing, and because of that reason there will be a lot of consolidation which will happen, especially in certain areas like technology. Secondly, government policy has driven certain M&A opportunities. Reserve Bank of India has come up with SDRs, which is strategic debt restructuring, which may create opportunities for acquisitions, merger and acquisitions, which we can discuss a little later. Private equity also today are in a situation where they are looking at an exit since they did not get good exits in last many years. That exit also will create a lot of opportunities for acquisition. So that's the trend we are looking at it from exit perspective, from deal perspective. In the sectors which we believe this year we will see a lot of action. What we believe is that technology sector will drive M&As in 2016. If you ask me for the breakup, IT services and BPO, which will be consistent or similar to what it was last year. I don't anticipate increase in activity, but it will continue with robust activity which we have seen in the last few years. E-commerce and internet companies, that's where we'll see a lot of activities in deal making. In internet companies, again, if you ask me where there will be a lot of activities, it will be in fintech area, in medtech area, and edtech area, and consumer services. This is the area where we are expecting a lot of activities to happen. In addition to technology areas, some of the other areas where we expect a lot of activities this year includes oil and gas, especially because the oil price has been quite low, and that is going to bring a lot of upheaval in the industry. So we would expect to see some people taking benefit of the opportunity, some people consolidating on that front. Secondly, we will see in pharma, life science, healthcare area. Traditionally, that area has been active for last 3-4 years. We expect it to continue to be active and actually even do better. Education area, India has started seeing activity more recently than before, and we believe that education will become very active this year again. And financial services industry, which has been active but will continue to remain active. And specifically in fintech and financial service industry, we see that there are 3 or 4 areas where there will be a lot of activity. One is on payment system places. Second, it is on debt places. We'll see a lot of activity. And we have already a lot of payment banks and small banks are coming into picture, and because of that, you may see some activities also. I think with this, Nishith bhai, I pass it to you.
Yeah, I think you talked about healthcare, and I think who better, Daniel Carberry. Emering, you got a lot of experience in deal making, and can you just tell us a little bit more about your consideration of structuring a deal?
Thank you very much. So first, to an American, India is complex. It's very complex, and I've come to learn there is no such thing as India. There's the States, and so as we approach deals, you've got to really understand what you know and don't know about India, and think about strategically why you're looking at this deal. What is it bringing to you? The challenge on a deal-making process, as everyone knows, it's fast, it's furious, late hours, everyone's rushing very quickly, and yet you have to have this sort of very strategic, planful mind. We had the chance recently of doing some work with NDA and on a deal that for its size was very complicated. Involved India public company, very thinly controlled. It was, if you apply American or Western models to it, you will come out with the wrong answer very, very quickly. And it's it was quite a learning. I thank the team that worked with us here. But you've got to deal with, again, understanding the difference between different accounting standards, different tax, legal processes, legal systems. I think that was just touched on before. The history of, if you want to do a deal, you want certainty. You want to be able to say if there are going to be warts, there are going to be problems. I want to be able to clean them up quickly with an indemnification. By the way, I'm not a lawyer. I'm probably I may be one of 10 people in the room not a lawyer. So anything I say, my general counsel will disclaim for me. But you've got to understand what you can do and what you can't do. And in that consideration of doing structuring for a deal and preparing to do a diligence very quickly, bring in the team who's got that capability. Don't underestimate it. If you do, you'll be very sorry. Different kinds of capabilities in different countries. And the other challenge I have is that people's knowledge of India is very dated. So interestingly, I work with a lot of colleagues who are Indian Americans, and if they haven't really worked in India in the past 10 years, their knowledge could really steer you wrong. The country is changing very quickly, certainly the current government. And so you really need somebody who is very, very current in the financial, legal, structural, tax processes. And 2 months ago, I wouldn't have even said it was quite as important as I can tell you today. It's incredibly important to have somebody who's very current on what's going on. Because the deal can get the diligence part of the deal can get very complicated. So other areas, most deal people would say know your target, know who they are. Learning about Indian companies is much harder. You can't go on Google and just type it in. You don't have a lot of the publicly available reference systems where you can type people's names in. So we took the task of saying we did an integrity check, we did a background check, we did HR checks, we did things that you might take for granted in certainly the U.S. or certain countries of Europe. And you need to go do those things. You really need to know who your players are, because also the U.S. government has certain rules, Foreign Corrupt Practices Act and others, that if you make big mistakes, the deal can cost you a lot. By the way, if we really were honest, the same applies if you're doing something in Hawaii or Maine or North Alabama. So we just sometimes overlook that. Know who your target is. But knowing the people, knowing what the real capabilities are, understanding the differences by state and by region. If you're in Mumbai or Bangalore, where is it going economically and commercially? Is this going to be a good place for you to grow? Think of it very strategically. My sense is, if you structure a deal for India very tactically because you think you're going to get cheap labor, you are going to make an enormous mistake.
Mm-hmm. Thank you. So Mansi, I think tax has always been an interesting part of every deal making. So would you want to give some tips on structuring from tax perspective, the M&A deals?
Sure. I think Daniel has very nicely laid the background that how complicated it can get, and tax is, Indian tax is no surprise. It can get very complicated, and I think both buyer and the seller have a lot of groundwork to do before they can come to a conclusion on how they'll structure a transaction. As far as inbound M&A transactions are concerned, I think I'll break my response in 3 parts, saying who's your acquirer, who's your target, and what's your mode of acquisition. So when I say who's your acquirer, what I really mean is who is the acquiring entity. You could do, for instance, if we take a US company today looking at India, it could make a direct investment and do a direct acquisition into India. On the other hand, they could explore having an intermediate holding company. And while from a US perspective, tax perspective, you may be able to achieve the same tax consequences for the US entity, you may result in mitigating your Indian taxes if you use an intermediate jurisdiction. So for instance, just to give you an example, if a direct investment is made, US source rules for capital gains and Indian source rules are opposite, which basically means that at the time of exit or a subsequent sale, you'd have taxes in both jurisdictions and a treaty that does not mitigate that. But on the other hand, if you were to make a sale from, say, a Mauritius entity, so you invest through Mauritius into India, which was an equity investment, you may actually end up with capital gains which are not taxable in India and minimally or zero taxed in Mauritius, and you can distribute that up to the US entity. Similar structures can be explored even if you're looking at debt. And we have, for instance, investments from Netherlands or Luxembourg that can be looked at if you're looking at a mixture of debt and equity. So I think the first thing that has to be, any buyer needs to think about is which entity are they going to use to acquire? Are they going to set up something new to make this acquisition? And then that'll lead me to the second point, who's going to be your target? Now, if you're looking at a group which has foreign presence, are you going to acquire shares at the offshore level, or are you going to acquire shares of the Indian entity? That's an essential question, which also ties in to my mode of acquisition, but I'll come to that in a minute. As far as the target is concerned, for instance, if you're doing, sometimes you think that you're doing a complete foreign transaction, and yes, there is an underlying Indian subsidiary, but I'm only acquiring shares in a foreign entity, and I'm fine and I don't have Indian tax consequences. That's the wrong answer. There's a possibility that you might have Indian tax, and of course there are others, but I'm going to focus on tax for my response. You could have an indirect transfer tax in India, which is something similar to what Vodafone has faced. And I know that's old news, but the whole controversy resulted in us changing the law, and now we have a provision in our act which basically taxes indirect transfers, and that is something to be careful of. Of course, if you were doing, you could also structure the transaction where you're doing a domestic, where you're buying shares in an Indian entity, and that results in capital gains for the seller entity, and you think that is cleaner. But there is, again, in that also there's a possibility, and this is unique to India, that it is not only the seller's tax liability, but there's also an obligation on the buyer or the payer to withhold. So if it turns out that the transaction was taxable and tax wasn't paid by the seller, there is some amount of exposure that the buyer has, and they need to be aware of that. Of course, a seller always appreciates share transactions because they get capital gains and they get the consideration directly paid to themselves. But the other modes of acquisition which can be considered are an asset purchase or a business transfer, which of course you'd need an Indian entity to set up an Indian entity or use an already existing Indian entity. And from a buyer's perspective, a lot of times they prefer an asset sale simply because it gives them a step up in the assets which they wouldn't get had they done a share transaction. Also, sometimes you don't want to acquire a company with all its liabilities, or there's a pending litigation that you don't want to be a part of, and you'd rather cherry pick the assets that you're going to acquire. So in a lot of transactions, we've also seen that taking place. That comes with its own pros and cons and tax liabilities in India. And the one thing to be careful about is the successor liability that could come along with that, along with the business transfer, if it's not, I mean, if the I's are not dotted and T's. So just, you have to take care even in case of an asset acquisition, but a lot of times there's a discussion of whether we should do one or the other, and which is not even necessary. For instance, we were recently working on a transaction where it was a group that had presence in US and in India, and because of exactly the consideration that I was saying, there was pending litigation, but at the same time you wanted it to be tax efficient in the US. For all these transactions, ultimately we did a share purchase in the US and an asset purchase in India for the same group, so there were 2 targets, 2 acquirers, and 2 separate transactions. Of course, that has its own tax risk because there's a possibility that the Indian tax authorities can argue what you paid in India is not enough and some of it was actually paid offshore. So I think that's a summary that does not do justice to some of the issues that can come up, but you have to think of each part of the transaction when you're doing an M&A in India.
Let me turn to Nishchal, I think, and you did some very innovative structures, and would you like to share some experiences?
Sure. So, in 2015 we worked on many innovative structures. I can share few structures. The first one being, as you know, in US there is a concept of SPAC, Special Purpose Acquisition Companies, which are also called blank check companies. These companies don't have any assets and they raise funds from the investors. The typical model is the US SPACs, they acquire an operating company, and there is a period of 18 to 24 months which is there for deploying the cash to acquire the operating company. And then that operating company is reverse merged with the US PAC. And what happens because of the reverse merger is the founders of the operating company, they get stock in the US PAC, which is listed on NASDAQ. Now, this structure is very common in other geographies, but when it comes to India, there are certain challenges. So there were a couple of SPAC acquisitions which happened in India last year, one being Silver Eagle. They acquired Videocon DTH entity for about $375 million. We just last week there was one more SPAC acquisition which happened where Strand Life Science was acquired by Netex's Inc. So the interesting thing from an India perspective is the reverse merger where the operating company needs to merge with the US PAC is not possible in India, because in India under the corporate laws, an Indian company cannot merge with a foreign company. So the interesting thing which needs to be done is how do you achieve the same structure when you are faced with the hurdles under the Indian corporate law. And there what we have seen, the biggest issue which comes up is tax, because when the founders transfer their shares in the operating company to the US PAC, there is a phantom tax which they have to pay, which means that there are notional gains which get realized, but they don't get any cash. The only thing they get is the stock in the US PAC. So there are certain interesting structures on, there's some restructuring which needs to be done in India to achieve exactly the same result as any other US PAC would achieve if it is acquiring or reverse merging an operating company with it. So that's one structure which is quite innovative and is becoming popular in India. The second structure that we have seen is the founder or the promoter funding structure. What happens is there are a lot of Indian listed companies whose stock prices are depressed, and the founders of the company, they want to increase their stake in the listed companies, but they don't have the required funding to increase their stake. And that's where we have again seen some innovative structures, one being KKR. They invested in Apollo Hospitals holding company, where the terms of the lending were very interesting. The debentures which were issued to KKR were convertible into the equity shares of the subsidiary after a certain period of time. So the benefit of this was, one was, the promoter is able to, or the founder is able to discharge the debt which it has with other lenders to the money which comes from the investor. The second advantage is because the stock prices are depressed and it's a good time to increase a stake in the listed company, they can use this money to even increase the stake. And this structure has become very popular, became very popular in 2015. Because as all of you know, our capital markets are not doing that great in the last 5 years. In fact, we just had 8 IPOs in 2015, 3 IPOs in 2014. So this is the right time for a lot of these founders to increase their stake in the company, and this is one structure which has been used a lot. Another structure which as such as a concept is prevalent in all the countries, which we call earn-out. But it's a bit difficult to structure in India. Just to explain what earn-out means, typically in any earn-out structure, 100% of the shares need to be transferred upfront, and certain percentage of consideration is paid upfront, and the balance is paid depending on the performance of the target company in the next 2 to 3 years or whatever time has been decided by the party. Now the issue with that is under the Indian exchange control laws, Reserve Bank of India does not permit any deferred consideration by a foreign acquirer. So you cannot acquire 100% of shares and just pay 70% of consideration with 30% being paid in future. So that's something Reserve Bank of India is not comfortable with. So there also we came up with some certain innovative structures where instead of transferring 100% on day one, 95 or 98% is transferred upfront, and for the balance 30%, which is the earn-out component, depending on how the target company performs in future, there is a smaller stake of 2 to 5% which is remaining gets transferred. So because there is always a consideration which is getting transferred against a transfer of shares, Reserve Bank of India does not have any concern with those type of structures. Another one which we worked was what we call externalization. This is something which we did with a very large e-commerce company of India. And the reason why we did this externalization was because a lot of foreign investors prefer to invest in foreign companies but with Indian businesses. The reason being the exchange volatility has eaten up a lot of dollar IRR for number of foreign investors. So just to give an example, the number of investors who invested between 2006 to 2008 in India, when $1 was 42 rupees. Today the same $1 is 66, 67 rupees. So almost 30% of IRRs got wiped out just because of the exchange rate fluctuation. And that's where we started seeing more and more foreign investors wanting to invest in foreign companies in dollar, but having Indian businesses. And there what we started doing was some of this early stage medtech, fintech companies. We started externalizing these companies to outside India, like changing the headquarters or the parent company from India to Singapore. And there we figured out that there are a lot of advantages apart from the exchange control volatility which this structure helps to contain. One is it is easy to list let's say a Singapore company on NASDAQ as compared to an Indian company on NASDAQ. Because once you are an Indian company to list on a foreign exchange, there are a lot of restrictions which you need to comply with. Second advantage is you can borrow cheap in Singapore as compared to what you can borrow in India. Third advantage is you can reduce your global effective tax rate if you make Singapore company or holding company. Because in Singapore, the tax rate is only 17% versus in India it is 34, almost double. So if you structure it well, you can externalize your company from India to Singapore or some other jurisdiction. And that again can, has been a very innovative structure which some of the companies have followed. And the last one, which is a recent change, what we have seen is a lot of IT companies in the US, which have their development centers in India, which are run by the subsidiaries, they always face this problem of cash trap because there is always a transfer pricing which needs to be followed. And because the transfer pricing needs to be followed, the Indian company has to charge on a cost plus basis to the US parent. So if the Indian company is spending $100, it has to charge $120 to the US parent. So there will always be cash that will be accumulated with the Indian company. And the biggest issue which all these IT companies are facing is how do you repatriate this money abroad, because it is just sitting in the Indian company doing nothing. And that's where one of the new structures which has come up is recently under the foreign direct investment policy, the government has liberalized foreign investment in limited liability partnerships. So if the same subsidiary is set up as an LLP instead of a company, then you can avoid what we call dividend distribution tax in India. And in the company structure, if you have to take out this money out of India, it takes 20% tax, versus in LLP structure, you can take this money back free of any tax. So this is one other structure which we have just started exploring with some of our clients on the IT side to ensure that they can take the money out of India without paying any taxes. So these are some of the structures that we have seen.
Yeah, I think.
Can I add one point? Just one of the things which Nishith mentioned on FD and LLP. Along with that, there is one more liberalization which has happened, which is very useful from structuring perspective, from M&A point, which is on stock swap. India is now permitted stock swaps. So, earlier the biggest issue was that when a foreign company was buying an Indian company and wanted to pay in stock, you couldn't do it, and you will need to actually pay cash, and then that shareholders will need to funnel cash back to the buying the stock of the foreign company. And sometimes it was possible, sometimes it was not possible. Now a stock swap is possible. Now that's a very good part from exchange control perspective. However, the tax issue still continues to remain, which means that will be a taxable event and not a tax-free event, which otherwise you would expect it here. Just thought, let me add one point.
Simon, what about deal terms, especially all these structures you're talking about, but some new trends have you find in deal terms?
Yeah, so in India, it's not just about tax. There are other considerations that one needs to look at when you're actually doing a deal. And I think the first sort of aspect that one should consider when doing a deal into India is, are you going to be acquiring control or not? And the reason why this is so important is because, traditionally, Indian companies have always been promoter-controlled. The minute you acquire a large stake, assuming you think you're acquiring control, ceding that control becomes a little bit difficult. So the first question that one needs to ask is the transaction structured as a control transaction, or is it a minority passive stake? I think a recent example of 50-50 JVs and not doing so well would be the McDonald's Hardcastle case, where when McDonald's came into India, they structured their investments into India into two separate JVs of 50-50% each, in both catering to the north market and the south of India. And what happened was that what control really meant sort of differed from one JV partner to another. Whilst in the south, things went smoothly, and the model sort of moved from a 50-50 JV perspective to a franchise model. The north didn't really have that good luck. There were sort of conflicts with the existing JV partner, Mr. Bakshi, and especially on how the company should be run, what are the expansion plans, who should be the CEO. And then you had a concern as to, the new term of the CEO, because in India today you can only appoint, a CEO can have 5 years typically as a term. The existing CEO was not voted on by the shareholders because of the conflict. It has gone into arbitration, but that has obviously stopped or impeded the ability of McDonald's to expand. So the first question that one should ask is this a control deal? If I'm acquiring control, what am I doing? How do I sort of further the business? Because in India, it's not just about acquiring a commercial division. It's not just about making commercial sense. It's also about relationships. And very often, when you acquire business, that business is the critical aspect of that business is the relationships through which that business is conducted. So that's a second element that that is extremely important to consider. Learning from these mistakes, Johnny Rocket, when they've been entering into India, have now just entered through the franchise model. So it's very important to make that one determination. The second is, stemming from control. Again, how do you sort of stay in India? Is it through the JV methodology, or is it, do you start off one arm in a certain way and, move on to different things in a JV model? This is what Boeing did. Boeing, I think, is one company that has done extremely well in India, and especially in the defense sector. And last year alone had about 2 billion in revenues in India. With that impetus, they announced a new JV with the Tatas, and are venturing into different fields through the JV model. If you're acquiring a stake in the regulated space, like I think Daniel alluded, there are complications in India, especially if you're acquiring, a company in the regulated space. You may not really have the freedom to choose what it is you want to buy. For instance, in the insurance sector, until lately, a foreign investor could only buy 26% of an insurance company. And if you see the joint venture between Tata and AIG, that was structured as a 74-26% joint venture, not necessarily because of commercial aspects, but because of regulatory aspects. The insurance sector now has sort of moved up; it's become 49%, and you see companies like Allstate making making statements about expanding into India and so on and so forth. So, in addition to commercial, in addition to relationships, the third trend to look out for is what sector you're investing and what do the regulations permit. The third, flowing from this entire thing is management buyouts. Now, in India today, ownership and control are very linked. They're not delineated. If you own, you also control. If you control, you also own. It's typically linked. But more and more, I think we're seeing, especially with private equity, sort of bringing in better practices into the country, we're seeing a slight delineation between ownership and control, where the management is now fueled to control, and the owners could be different. So we're seeing management buyouts. I think Blackstone was one such buyout when they did Intelnet. It's a management-run company, and the ownership is completely different. RBS, the Royal Bank of Scotland, is doing the same. So management buyouts are another trend in Indian countries, in India. I think the fifth trend is brand acquisitions. Now, we talked about asset purchases, we talked about tax concerns or tax issues there, but in addition to tax concerns, I think commercially people are looking at, especially in the pharmaceutical sector, are looking at brand acquisitions as opposed to actually buying other assets. A brand is also gaining a lot of importance in India. Johnson & Johnson was one such company that recently sold certain brands to a large Indian pharmaceutical company, Strides, which I think was in the newspapers a while ago. The last sort of trend that I will talk about is also stemming from control. Is companies, acquirers looking at acquiring listed companies in India. Now, maybe Daniel will think it's slightly more difficult to acquire a listed company because it has a lot of complications, it has a lot of implications. But we're seeing today, with valuations mismatch in the private sector, the listed space provides more real-time value as to what the stock is really worth, what the company is really worth. And acquirers now are looking to acquire listed companies. The issue with acquiring a listed company is the minute you have or you acquire 25% or more of the listed company, or if you acquire control, you need to make an open offer, and you need to sort of make an open offer to the other shareholders, and it's a mandatory buy of 26%, up to 26% of the remaining shareholders in the company. So going in, you could be sort of acquiring 51% absolutely on day one. Now, the consequences of that is, one is you may become a promoter in that company, which means you are responsible for control and management of the company, and not just to the company itself, but to minority shareholders, to the regulator, Securities and Exchange Board of India. So there are other interfaces that one needs to take care of. But a question that consistently is asked, is when we acquire a listed company, the valuations may be right, it may be a great fit, it's a great asset, and we have the wherewithal, the financial wherewithal to actually acquire this company. Can we sort of take it private because we don't necessarily want to keep a listed company? It has a lot of compliance concerns, compliance issues. The answer to that is yes. Our laws have now sort of been relaxed to now permit a company to acquire, make a public offer, and alongside that public offer also may have a delisting obligation or option given to the company. So you can, at the time of making a public offer, also venture to take a company private in that one transaction. So by and large, these are the trends we're seeing in Indian deals today.
Yeah, actually, I would like to turn to the issues of intellectual property and employment and stuff like that, because if you look at majority of mergers and acquisitions, the large values today, 60 to 70% M&As are all with the view to acquire IP somewhere along the line, whether it's hardcore or kind of data or anything else you call it, but majority of the M&As have been driven by some kind of an IP. Same way international tax, when we look at 60-70% of the cases we see are in the context of IP. It's transfer pricing of intangibles. We see issues on royalties, fees for technical services, and all those kind of things. So majority of the cases are also on the IP. So tax and structuring of IP and all that integration becomes very important. But on structuring, I just wanted to make one or two observations that all of us, like lawyers and accountants, we are all good at structuring. We go on whiteboard and draw all the exotic structures. You can frame them some point in time in lieu of your artwork. But what I see is that it's no longer about just structure. It's more of an architecture that you have to think. Even if you're structurally right, countries are now beginning to question. You already seen cases of Google and Starbucks in the UK and, in India as well. Now we are going to have general anti-avoidance provisions. So even if everything is right, but if it is purely with a view to avoid tax, then they denied the benefits. You have to make your story very, very good aesthetically. So how do you do that? So where we have seen a lot of disconnect is where people have got base structure on the whiteboard, but translating that into a document is another major thing that it doesn't really match. Articulation is not that good. Number two is this, that when you say structure from Mauritius or from Singapore, okay, now at that very point in time you must document your reasons for using Mauritius beyond tax. So if you go to Mauritius, what is the reason you will give? One of the reasons, and good reason, is that India and the US do not have bilateral investment protection treaty. We do not have, agreement for that. So US investment is exposed in that fashion to India, right? Like Vodafone case is surviving today because Vodafone has taken recourse to international arbitration under the BIPA, Bilateral Investment Protection Agreement. So there is no agreement between India and the US at this point in time to protect US investment. So therefore, Mauritius is one of the non-tax reasons to use, because Mauritius and India have very well written BIPA. Okay, so that is one thing. Second, for example, typically what happens, your Mauritius structure, if you are setting up a fund, on the top of it you have Cayman company. Why do you use Cayman on the one hand, and why do you use, now Cayman is more familiar to the investors, and enforcement of the rights is a little easier in Cayman. That's a non-tax reason. So you have to really justify at the time you are doing a structure. When you're doing any agreement, M&A or otherwise, your recitals, typically if you do not pay enough attention on that could create a problem. Because in recital you should write down a story as to why are you doing the way in which you are doing your structure or whatever. So those are some of the points I would like to make. But let me turn to Vaibhav. On what are the IP and employee related issues that you are encountering while working on deals in India?
Thank you, Nishith. Among all, when we do a deal, what we have found that employment and IP is one of the key reasons why the deal happens, and often there are a lot of questions asked on that. For example, we helped Cisco when they acquired NDS for $5 billion. 40% of employees of NDS were sitting in India. And obviously when you are looking to acquire a company, whether the employees, what you are acquiring, large number of employees that you are acquiring, is it something you need to be paying attention to? What we have found that in India, there are, first of all, employment is a state level subject, which means that if you have offices in multiple states, multiple regulations come into picture. There are more than 13 regulations which deals with employment. And secondly, when you are acquiring, you basically take over the role of the previous management. And often the recourse against previous management may be limited. So you need to be very, very careful when you do diligence on employment side. Also, some of the regulations have criminal implications. Now, for example, amongst all the regulations, one or two regulations which we focus on quite in detail is for what we call provident fund regulation, which is somewhat similar to your 401k concept. We have provident fund. Now, interesting aspect of provident fund regulations is that if you are non-compliant after you acquire a company on provident fund regulation side, especially in certain areas, then there is a mandatory jail term, which means that the law, both under the criminal law as well as under provident fund law, does not give discretion to the judge just to levy a fine and not mandate or jail term. These are one of the very, very few regulations we have found in our criminal code procedure where judge does not have discretion simply to give fine and have mandatory to subscribe imprisonment. Now that is something which is very onerous, and person who is responsible as well as director could be at risk. So this is something which we definitely tell people to be very careful about. Secondly, when you are acquiring a company through, let's say, business transfer or asset transfer, then there are a couple of ways you can acquire a company. One is you can transfer your employees under the transfer provision under the Labor Law Act. Second is you can ask all the employees to resign and rehire, right? And often when we think that in either situation, since we are doing a business transfer, we may not get any liability which was previous to the transfer. The answer is that just like tax, the liability under employment, specifically under certain regulations, actually flow with the business transfer. So you got to be even careful from that perspective, even though you are doing a business transfer agreement. The other part which comes which deals with employee and intellectual property is often you want to know whether the IP which employees are actually doing is belonging to the company or not. And this is where a couple of tips or a couple of points to be kept in mind. In India, under Copyright Act, while we don't have work for hire concept, which means that we really cannot do a work for hire agreement for anyone, for employee-employer relationship, this is something which is possible. So you can have a work for hire concept for employee-employer relationship, so for an employee. But if you have a consultant, and consultant also is a very common concept, specifically in technology industry, in IT services industry, where a lot of people are not really employed, but they are hired as a consultant, there the work for hire concept doesn't exist. So when you are buying a company or when you are looking at doing diligence, you want to make sure there is a proper chain of title of intellectual property where you are acquiring, especially from employees. Couple of other points when it comes to intellectual property. We need to make sure there is an adequate compensation paid to the employee for intellectual property to be there for purpose of ownership. On diligence side, what we have found is that often people will, when you see the list of IP which is being transferred or which you are buying, they will say, oh, we don't have any intellectual property. That's a very typical response we have seen from most of the companies. So they're figuring it out, what is the actual intellectual property which is there, and secondly, whether is there any liability which can come because of that intellectual property, whether it is because employees have used open source code material for which either they're claiming intellectual property or they have used it in a manner which makes the whole product open for public, or they have used somebody else's intellectual property without knowledge and as a result creating liability for the company which is acquiring. So those points are very critical to be kept in mind. One of the other issue which we have found is even when people say we don't have intellectual property, brand dilution is somewhat which has come up in a couple of recent cases. What has happened, especially now in technology companies, when you have a domain name which is the one driving force for your business. If there are other corporates or other companies outside that target company using that particular brand, and often people have not cared to go after them or to take them out, and as a result ended up risking the transaction itself. And this is an example which we recently encountered where transaction almost was called off because of brand dilution which happened, and as a result the acquirer was not sure whether the company which is buying has a right to operate that particular website, and which resulted in a major issue. So that kind of issues need to be taken care into account. One last tip before I close. In India, when you are purchasing any business, especially when you are doing an asset transfer or a business transfer, please make sure that you buy intellectual property, and specifically you are buying a trademark, in a separate agreement with a separate value given. And this is something which is critical because you will need to file the trademark assignment or trademark purchase agreement with the trademark authorities. You need to record it for you to get that right. And often they require specific value to be attributed to it. And you really can't say that the whole business was attributed to that particular value. And also it has implication on stamp tax, which is there in India. And as a result, this particular point we often see people miss out. We just thought I should bring to your attention. Thank you.
I think this is very interesting, and let me quickly turn to the other new thing that's now happening is that Indian companies are acquiring companies outside India. I think we can have a little word on that as well. So maybe I would like to turn to Mansi, if you can just quickly tell us, a little bit about outbound acquisition, what the rule is, and how do you structure that? We're a little short of time, but it will be useful if you can be quick.
I'll be quick. So I think just like the inbound acquisitions, as Simone was mentioning, that there could be regulatory considerations, so you could have a restriction on how much you can acquire or what price you can acquire. Similar restrictions are also when an Indian company is trying to make an acquisition abroad. So for instance, an Indian corporate can make offshore acquisitions only to the extent of 400% of its net worth, and it cannot go beyond that. So that's a limitation that has to be kept in mind whenever an Indian entity is looking outside. If it was, for instance, a shareholder or Indian individual who's looking to make an acquisition outside, they have separate restrictions. Currently under our schemes applicable to resident individuals, an individual can only remit up to 250,000 per financial year. And as a family, close to $1 million. So these limitations have to be kept in mind. Once you've determined how to make that acquisition, one of the things, like again, I'll draw reference to the inbound acquisitions, here also we could look at a holding company jurisdiction. Of course, the considerations are slightly different from a tax perspective. Unlike the US, currently we don't have a CFC regime. So if you actually set up a holding company which is in a tax-efficient jurisdiction, you may be able to achieve a deferral which, for instance, in a similar case in US, you may not because of the CFC or PFEC rules. So that, from a tax perspective, is good. You do not need to get the money back into India. You can use it for making further acquisitions or expansion of your business. It is also good in giving you flexibility, and I think these were some of the aspects that Nishchal had mentioned when he was talking about externalization, because you can use that entity for a foreign listing, you could possibly use it for leveraging, and which is also something that we've seen often, that the intermediate entity does the borrowing. In that way, you can actually go beyond the 400% net worth, not from India, but that's what you put in from India, and you could borrow abroad. So that helps in increasing the pool. And I think one of the last considerations I'd like to mention is that recently we've always had, for corporate residency of a foreign company, the test being that it should, as long as it's incorporated in India or wholly managed and controlled from India, then you'd be treated as a residence. But recently our rules have changed, where they've tried to introduce what Ambassador Mule had earlier made reference to, called the POEM, or the place of effective management, and that is somewhat of a tax risk for foreign entities, especially in outbound, where you'd have Indian entrepreneurs who'd like to be part of the board. All of that is sort of gone into muddy waters at this stage, because they came out with the rule. They said you now have place of effective management, which is basically where your key commercial decisions are taken through the year. And then they came out with draft guidelines, which they've talked about what they'd look into in determining whether there's a poem in India. And I think there's a small booklet, which was among the material that we kept in front of you, which talks about the guidance that was issued. And if you go through it, you'd realize that it has changed what we had, an objective test, to a completely subjective test.
Yeah.
And that going forward, that should be something that one needs to watch out for in outbound acquisitions.
So poem is not that beautiful as normally people think of. It's a place of effective management. In simple words, if you have a foreign company and if the majority of the directors are in India or some major commercial decisions that are taken in India, then the tax department would treat the foreign company as a tax resident of India and would tax it on a worldwide income. I think that's the new thing that is coming up. It's been somewhat resisted, and our own presentation is there in that small booklet to the government we have made. We won't go into detail, but happy to take questions. After a couple of questions, I also want you all to ask any more questions that you have. So, but Nishith, what about LBOs, in India, leverage buyouts?
Sure. So I think there is a myth that leverage buyouts are not possible in India. So that's not correct. There are ways to structure leverage buyouts in India. The only concern for LBOs in India is the Reserve Bank of India does not allow the banks to fund for acquisitions. So, but there are other ways in which you can fund. For example, if you want to push down debt into an Indian company from outside India, there is a listed bond route which is available where a foreign company can push this money into the Indian company, and the Indian company can use this money for making acquisitions, and there are no restrictions that this funding cannot be used for the purpose of acquiring shares. So this is something which we have done it for number of deals in India, because the biggest challenge in India is to take out money on equity is very tax inefficient, is also difficult from a regulatory perspective if you want to take your money out. Just to give an example, on equity, if you want to pay dividend, there is a tax of 20%. If you undertake a buyback of shares, there is again a tax of 20%. If you want to take out your money back, you cannot take out more than 25% of net worth in 1 year. Versus if the same money is put in the form of debt, you can take back 100% of your money at one go. On any coupon that you pay on debt is a tax deductible expenditure for the Indian company, which means the corporate tax rate of India, for an Indian company is about 34-35%. So any coupon that you pay results in a tax saving of 35%. And if you are coming through a jurisdiction like Netherlands or Luxembourg, where the debt is infused through these jurisdictions, the withholding tax rate is only 10%. So for every $100 of coupon paid, you are saving $25 of tax, which means $35 is the tax saving in India and $10 is the withholding tax. So the net arbitrage is 25%. So pushing down debt has become very important in Indian deals, and we keep getting inquiries from our foreign clients that we don't want to acquire the business direct, by funding the Indian entity through equity. We want to use more and more of debt, and suggest us ways in which we can use more debt. Now, there are three modes in which you can raise debt in an Indian company. One is what we call external commercial borrowing, which is the foreign currency borrowing, which is denominated typically in dollar terms. Most of the ECBs are in dollar terms. There are restrictions on how much coupon you can pay out, who can be eligible lender, who can be eligible borrower. But most important is there are end-use restrictions. And one of the end-use restriction is that you cannot use the ECB for repaying any rupee loan or for acquiring shares. So ECBs don't work for LBOs, but there is another concept of rupee-denominated bonds, which was introduced in 2008, where this end-use restriction is not there. So you can pretty much use a rupee-denominated bond, raise it in an Indian company, and use it to acquire shares or a business of another Indian company. So broadly, debt has become more popular than equity in India in the last few years, and especially on the private equity side, debt has become very, very popular for the simple reason that a lot of LPs who had invested in India or India-focused funds, they haven't got their money back because most of the investment happened in equity. And because the investment happened in equity, because of the tax issues, the regulatory issues, they have still not seen significant amount coming back. Versus the same amount being put in the form of debt, they keep getting regular coupons. And at least that's something which, LPs are comfortable with versus investing purely in equity funds. So,
yeah, I think you're right that debt push down has become more interesting, both from regulatory and tax perspective, and also from US-India perspective. The tax rate has been brought down, So that's something that what. Let me turn
one additional point. What Nishith mentioned on rupee bond, government allows that rupee bond to be hedged, so that is something just to be kept in mind.
Yeah, and I think just to add to that, I mean, there's one sort of commercial advantage to getting rupee debt. It's that today banks in India charge, exorbitant interest rates. Cheaper borrowing is available offshore, and there is no real cap in terms of regulations on interest rates. There's nothing that stops you from creating your own interest rate. So, to that extent, acquirers offshore that have, or companies that have access to offshore debt are at an advantage instead of just borrowing in India.
Yeah, most of you know we have exchange controls in India, so they're currency controls, and therefore some of these things become very important to design, especially when it comes to acquiring or business or company in India. But let me just turn to next point about due diligence. Daniel, could you share some thoughts on how different it is from what you see here in the U.S. and what's the what's the nature of the diligence that you have seen?
Well, thank you. I think a lot of the folks here touched on these topics. Employment is different. The number of categories of temporary workers, contract workers, et cetera, and as I'm just taking notes on the consequence of not paying funds correctly, it's different than it would be in, say, the U.S. That's a large piece of it. The understanding liabilities. Typically when you're trying to do a diligence and you're trying to acquire something, every facility has warts. Every company there's a reason they're selling. Right? If it was a pure shining star, the odds are they're not selling anything. And when you're acquiring, you've got to know what you're looking for. And in the U.S., typically there's a pretty clean process for and timetable for cleaning up liabilities. Learning that in the Indian court system historically, and was just commented on before, if that takes 8 years versus the U.S. is 2 years, that kind of uncertainty adds a lot of complication because you're not really sure who's gonna indemnify that debt, that liability, that land dispute, that whatever. So understanding that and figuring out how to structure your deal around that's pretty important because that timeline will be much longer. The publicly available information, again, is so different that compared to what you can get, say, in the U.S. from so many sources, that you just got to do much more homework. You've got to bring a team on that knows tax, legal, finance. You just have to have the right people who are close enough to it. In the U.S., you can do it more from afar, and I think India, you really have to have people who really know, who live in the area where you're trying to target, and that's quite different. Financing. How are you going to finance deals? I'm actually taking notes right now from all the panelists' comments. How you finance has a lot more dimension to it because of the ability to move money in and out, and certainly the pharmaceutical sector is very, very important to India, and the rules around that might be very different from, say, an IT company.
Yeah. Simon, you want to add something? You have the same experience?
Sure, yes. So I think due diligence is an important aspect in any Indian deal. There are, I'll just sort of break this into two or three buckets. One is, it depends on what sector you're acquiring, if it's regulated or not. If it's regulated, there are even more compliances that you need to be wary of. If it's not regulated, then you have the standard diligence checks. The second bit is when you find an issue, and if you find a concern, how do you sort of mitigate that issue, and how do you take that into consideration? Some options that are looked at is, to benchmark maybe valuation, so that you take that into your into the valuation fold and get what you need of it. Advisors are typically good at estimating liability, especially from a financial and tax diligence perspective. You can estimate liability and take that into consideration. The third is if you're doing a listed transaction, if you're doing, if you're acquiring a listed company, a public listed company, we have We have laws that prevent disclosure of unpublished price-sensitive information. However, there are certain exceptions to that rule. So if you're a listed company and if you have UPSI, can you do diligence is question number one. The answer to that is our laws have recently changed to provide for acquirers to actually do a due diligence. The only consequence is that if you are doing a due diligence and if you are not going to be making an open offer, that means you're acquiring less than 25% of the company, that due diligence needs to be given to the board of directors, and the board of directors of the listed company needs to take a cognizant call on whether to disclose that information to the public or not. So if you're acquiring, if you're doing 100%, if you're doing a large acquisition, or if you're doing a slump sale wherein you're not really acquiring the company as a whole, but you're acquiring just a few assets of the company, especially in those circumstances, the risk appetite of the seller and the risk appetite of the buyer are completely different. And therefore, it is important to ensure that A, the diligence process is conducted properly, two, that the report that goes to the directors does not have observations or doesn't really have analysis by your advisors to you, because that then could become a public knowledge. So all in all, diligence is an important aspect. Can you mitigate against it? The answer to that is yes. You have, in India, we have US-style representations and warranties, where you can have both a rep and warranty, not just a warranty, and try and indemnify for that on the basis of a contract.
Yeah, very quickly on diligence, one point that it may be in many circumstances better to do it through a law firm because the benefit of privileged communication, what you call client attorney privilege, is not available to non-lawyers. And so the cases that happen, like in case of Vodafone or otherwise, courts came down heavily when a due diligence report was not being presented to the court initially. They said it's confidential, but it was not done by a lawyer, so it could not be done. The principle is that no court of law can compel the communication between client and attorney to be presented to it. So under that, it is very important when you do a due diligence, most of the things are bare, everything comes out, and you want to make sure that that is reasonably protected, reasonably, remains confidential. So I think that is one point you might want to bear in mind. I think it would be a good idea now to, break one-way traffic and go to the other side, and if any of you have any questions or any comment or something like that, we can have some of them. Yes, Avinash, welcome.
Thank each of you for a really excellent presentation. You were all very, very insightful and articulate, so my congratulations. Nishchal, I have a question for you. I've been practicing as a corporate finance lawyer for about 25 years, and a large part of my practice is focused on leverage finance and debt capital markets. And so I found your comments and insights on the development of the bonds and the external commercial borrowings very interesting. And I think the second flavor of borrowings you were describing have been somewhat obviously named masala bonds, if I'm correct, the rupee-denominated bonds. My question is, given the development of debt and the importance of debt in fueling LBOs and other transactions, what's the state of play of creditors' rights and the bankruptcy process, which has always been, to my knowledge, and my knowledge is limited in this area, has been sort of underdeveloped, to say the least. How has that jurisprudence sort of kept up with now this sort of rise of debt, if you will? Thanks.
Sure. So just on the masala bond. So before the masala bond came in, there was this concept of rupee-denominated bond which was introduced in 2008. Masala bond is something which is a recent concept. So that's a third type of debt which you can borrow. One is foreign currency borrowing, second is rupee-denominated borrowing, and third is a rupee-denominated external commercial borrowing. Now, what I was talking about was the second one, which is the rupee-denominated bond, which was introduced in 2008. Because even in the masala bond, one of the induced restriction is you cannot acquire shares or you cannot use it for capital markets activity. So LBO is more possible with the second type, rupee-denominated bond, which was introduced in 2008. Now on the creditors' protection rights, what we have been seeing is clearly a lot needs to be done. But one of the things which we have seen is typically when it comes to creditors protection, there are two things which are important. One is the liability crystallization, and second is the enforcement of the actual court decree or arbitration award. Now, one of the things which we have seen is the first part, which is the liability crystallization. That typically used to take a lot of time. Because the borrower used to say, I owe only this much. Lender used to say, no, this I owe 2x of what the borrower is saying. That used to take a lot of time, which of late the parties have started doing is they are making this subject to arbitration, Singapore or LCIA. And because of this, the liability crystallization process has become very fast. So what used to take 7 to 10 years is now happening in 1.5 to 2 years time. And any foreign arbitral award, which where India has a reciprocity with that foreign country, is directly enforceable in India as a court decree. So overall, we have seen this time period of 10 to maybe 12 years getting reduced to 3 to 4 years, which again is still not the best thing, but at least you manage to wrap up the litigation before the end of the fund life, I would say that.
Simon, you want to say on bankruptcy?
And bankruptcy code, maybe Simon.
Yeah, so just to add, I mean, there are various ways to protect a creditor, right? One is, you're right, in India today, the maximum protection is given to banks, whether it's through the SARFAC or whether even it's through the SDR, which is the strategic debt restructuring. But having said that, if you see bondholders today, like the FCCB lot, they've managed to sort of stake their heels into a lot of work by Indian companies and have sort of gotten their way very often. It's not always today that so the convertible bond, the FCCB, no longer worked as a convertible bond, but was pure debt. But that being said, there are various ways to sort of protect against the creditor risks. One way, like Nishith just said, was have your documentation subject to arbitration. But again, it depends on your security. If you have today, a mortgage over land, for instance, in India, to enforce a mortgage, you have to go back to court. But this is only if you have mortgages other than an English mortgage, which means that the land title is passed on to the lender on day one. So if you have certain types of mortgages, you may not even have to go to court of law to actually enforce it, which makes your time period even sort of lesser in terms of enforcement. Similarly, for pledge of shares, you can get some. You don't need to go to a court. You could have that subject to arbitration. So how you create a security package, it needs to be you need to be a little bit commercially astute given the protections under Indian law. And second, the bankruptcy law today, it's not yet enforced, but we are seeing a lot of momentum on that. When that comes in force, and I'm not saying should it come, I'm saying when, because it's going to be anytime soon. There are going to be additional protections given to creditors, including unsecured creditors, including creditors that are offshore. It's specifically included in the bankruptcy code. So. With the impending amount of legislation that is sort of coming to aid and protect investments, I'm sure, if as and when we have this conference next time, I'm sure our answers are going to be different.
Yeah. Any other question? Yeah. Please tell your name, organization, and quick questions.
My name is Rama Rao. I just retired. So I don't know which organization I refer to, but I can say that I retired as the director, head of the World Intellectual Property Organization's office here in New York at the United Nations. So, and I used to be the legal advisor in the Indian Foreign Ministry once upon a time. And it so happens, incidentally, that when you started your firm 25 years ago, then in the government we were doing the drafting of bilateral investment agreements, the first model, which somehow I committed the mistake of drafting. That was ages ago. My questions now relate entirely to intellectual property by Weibhoff. And thank you for also raising that, introducing the point that 60 to 70% of the litigation of acquisitions of mergers acquisitions, or with reference to intellectual property, are in litigation with reference to India. Now, having said that, this seems to be the examples that you've said, Vaibhav, seem to refer to the kind of copyright issues, the kind of human/technical capital program developmental issues. By and large, globally, having understood that, if I would want to be corrected by you on that, but by and large, in the broad intellectual property litigation or acquisition of companies globally, what we are referring to is the generation of the intellectual capital in terms of the next app, in terms of this, what makes Apple, what makes Samsung, the biggest IP case in California to Korea. That is the kind of intellectual property that is...
So what's your question?
The question there is, how would that patents come to instead of work for hire rule on copyrights? I'll discuss rest of it later in cocktails.
It's a good question. Let me answer. I didn't refer to patent because in India still the most important intellectual property which we are seeing is in copyrights, because in technology industry, for example, software, you can't patent it. Patent in pharmaceutical is very, very critical, and we are seeing more and more litigations and more value ascribed to patents in pharmaceutical sites. On technology sides, one of the biggest issue in patents, and the reason why we are hoping it will become as critical as what you mentioned in the US, but it's not yet, and there are two reasons for it. First, the amount of time it takes to get patent basically is so much that by the time you get patent, your intellectual property is already outdated. And as a result, that is one reason we don't see too many patents in India which is enforceable or which is enforced on technology side. Now government, and this is one of the things which Prime Minister Modi announced during the startup action plan, is that they have a double the number of patent examiner. They are also outsourcing some of the patent examiner work to IITs and other people. And within 18 months, they are going to reduce the backlog completely. And that's the focus they are doing it. And maybe after that, the technology patents will become slightly more important in India than what it is today. And secondly, since India does not give software patents, a lot of in technology industry, in software industry, that becomes less relevant. So we still don't see, I don't expect that the Samsung versus Apple kind of litigations will become very real in next three to 5 years. I mean, maybe 3 years it won't, maybe 5 years it will.
Yeah. You have a question.
Ram Balani with FDA Smart. As Mansi pointed out, the draft guidelines for POEM, Place of Effective Management, is so darn subjective. What do you all foresee is going to happen with Indian businesses, apart from, of course, contributing more revenues to legal service firms?
Say that again.
The draft guidelines issued by CBDT,
POEM.
Yeah, POEM,
Yeah.
are so subjective, from wholly controlled interest to place of effective
Right,
management, right? So evaluating that place of effective management becomes a huge challenge. What do you all foresee is going to happen with Indian businesses, apart from, of course, increased services requirements for legal service firms to assist them?
Mm-hmm.
Yeah.
So what's going to happen? Whether foreign law firms will be allowed to come in? Is that the question?
No, just generally in India, how will businesses react to it? What do you think will happen in the Indian business climate?
Well, I think it's a matter of evolution, and already there has been some move for opening up. At some point in time, it will have to have. But in 1991, most of the Indian companies are afraid, of foreign companies. But over a period of time, Indian companies acquired some of the largest companies in the world, like Jaguar, which nobody could revive. Indian Tatas could revive it and make it different, So I think there is some degree of fear of unknown. But over a period of time, I think people are becoming more and more confident. So, there will be some resistance in some quarters and some of those things, because protectionism or protection, everybody likes protection. Who doesn't like it, right? Including the US. The worst form of protectionism, in my view, is immigration. It's against human rights, number one, correct? And it is nothing else but protectionism, if you put it honestly. Because you want to protect jobs, right? Because we have only exportable surplus which cannot be produced in factories, human capital. And we can't export it here easily. So each country has its own issues. I would not be judgmental whether right, wrong, good or bad, but protectionism works all the way. So India wants to open up services. Most foreign companies would want to open up goods. And of course in the process some of the services will have it. So it will be give and take some point in time. But I think it would open up. It may take a couple of years by the time. But first, in the legal service, it will be possibly more of a phased approach, so that foreign law firms will be allowed to practice only foreign law, and then maybe further on and gradual process. But it will not be that straight away foreign law firms will be able to practice Indian law. That would be. In fact, the whole issue arose, if you see early 90s, the history of litigation was that foreign law firms set up liaison offices to practice foreign law, but in the process they began to advise and practically in a pseudo fashion began to also practice Indian law. That's why some of the people, created litigation and all that thing. It delayed the whole process by 30 years, So these are realities of life.
So just to add to what Nishith said. On the poem, because of the concept is so ambiguous, because it says if your majority of the commercial and key management decisions are taken in India, then the foreign company can be deemed to be having place of effective management in India.
And tax resident in India.
Yeah. So the biggest problem with that is, first of all, which commercial decisions will be considered. For that nobody knows. Which decisions will be considered as key management decisions, nobody knows. And the previous test, which was on control and management, was more objective. It was easy to determine whether the control and management is in India or outside India. But this, as you rightly mentioned, it's a very subjective test. And technically the way, if tomorrow, let's say, Satya Nadella comes to Hyderabad, right, for a 2-day trip, and some major acquisition decision is taken in India, does that mean that Microsoft becomes an Indian tax resident because the key management decision of Microsoft was taken in India? So like this, there are a lot of other examples which people keep asking, and a lot of representations have been made to the government to take back this concept of poem and retain the earlier concept of control and management. But we'll have to see, because I think government wants to do something about this because of the same structures which I mentioned on externalization, where Indian companies are externalizing abroad. And this is becoming a big concern for government, because together with corporates, even brain drain also is happening. A lot of fund managers are also going out of India. So some of these laws which they are introducing are to also tackle these issues of not only the corporates but even the humans migrating out of India, and take care of that. But
Well, I've read the guidelines, and I think one thing that would help is to translate Indian government English into Indian private sector English. I mean, it is so bloody poorly written, it's unbelievable.
Yeah, that's true.
So I think these are some of the things that are happening where interesting times are in front of us. We're going to see very exciting time, because when things begin to open up, people change, you are on the toes, it's very important. It's as good as what you see here. Anyway, I do not want to, sorry, can we take up, because we are slightly out of time.
I just wanted to know
Oh, sorry.
how India is looking at the international patents being enforced in India, especially in the pharmaceutical industry.
I think, Vaibhav, you better.
Yeah, I will quickly answer this. So, India, actually, pharmaceutical patents in India are being enforced. If you have filed patent and got opt-in patent in India, there are 1 or 2 places where there is a divergence of view. One is an evergreening of patent concept, where incremental patents are being questioned, and maybe the courts are coming to a conclusion that the incremental patent should not be granted and revoking that patent. And the second issue is on compulsory licensing. And both these issues are internationally, kind of controversial and and well debated. But other than these two issues, you don't find issue on enforcing of patents in India on pharmaceutical side.
In fact, Weber is electronics engineer and also into patents as well. So he knows a little more than what I know. But feel free to ask him more questions. Can we just take a little, I think, change of the panel now? But I really want to thank all the panelists for their valuable inputs and also your questions. And of course, on behalf of firm, I especially want to thank Daniel, and present to him a small memento. Ankit, would you do me a favor to present to him?